Yo, what up, guys? This is Derp with another video about the IronMace vs. Nexon court case. This video is all about something being contested by both sides of the case, Nexon's employment contracts. We're seeing this kind of play out from Nexon and IronMace both. So I wanted to make a video about this because both arguments rely on this so heavily, right? Both sides are citing the employment contract drafted by Nexon in their arguments, so much so that Nexon's entire trade secrets basically hinges on it almost entirely, and IronMace is using it to try to get the case dismissed in the United States. So, to try to speed this along, what I'm going to cover is Nexon's annual salary contract and Nexon's IP protection contract. But why are these important? What does this mean for Dark and Darker and early access? And what is the TLDR? Right? So that's all going to be at the end. So if you want to skip some of this stuff, you feel free. I'll post a link to the TLDR in the description below. I'm going to be forward and a little bit blunt. These are the first really damning pieces of evidence that I've seen from Nexon. So buckle up. This one isn't as hopeful or for IronMace as, the last few videos of watching Nexon make a bunch of mistakes on all of their court filings. But yeah, as always, huge thanks to everyone who's been watching, subscribing, leaving comments. You guys are all champions. Like, you guys are amazing. I also want to thank everybody who's been helping out the channel through super comments, super thanks, and memberships. Specifically, I'd like to thank Shanks and Nick Gaming for becoming guild members on YouTube, as well as Kraken, Julin, and Toka for joining up on the Patreon. Massive thanks for everybody who's been watching live and leaving super comments. Mike, Kabian, and Overtask. I love you guys. You guys are amazing. I'll be buying a new mic very soon because of you guys. So thank you guys for all you guys are doing. You guys are literally changing my life for the better. But yeah, let's get into what we came here for. More court information. First things first, I want to start off with Nexon's annual salary contract. This contract is going to play a massive part in the case and might just change it from a copyright and trade secrets case into what could end up being like a simple copyright case, right? So to understand why this might happen, we need to first know what is in the contract. And I'm going to cut and paste all of the relevant bits just to kind of keep this short. And I'm going to start with Section 5, the obligation to comply with trade secrets, etc. Right off the bat, it says workers shall not disclose confidential information of the company obtained during employment to a third party, not only during the employment, but also after departure from the company. This means that they can't share any information that's considered confidential to anybody else. That doesn't work for Nexon, right? The other relevant bit is the worker shall not work in the same or similar industry that may infringe trade secrets for 1 year after retirement without prior consent from the company, right? So they have to get permission from Nexon to work for a competing company, essentially, or even in the same industry or similar industry. In this section, trade secrets are defined as confidential information obtained during employment. There are no examples or specifications involved, which makes this entire section extremely vague and easy for Nexon to enforce for almost any and all information obtained while under their employment, right? So obviously it's super vague intentionally for the exact reason they're using it now. It also prevents employees from working in the same or similar industries that may violate paragraph 1 for up to 1 year. This language is also extremely vague and does not give any specifics to industry, scope, or even type of work, which is shitty. And in the US, there's actually laws in place that prevent this type of language from being enforced. I'm not entirely sure of how that works in Korea. I am completely unsure about the legality of that in Korea. I'm not a Korean law expert. But yeah, this section alone, if on it by itself, would be pretty damaging to IronMace. Because not only did they start a competing company, they may have used confidential information to do so, right? So that's pretty damaging right there, just straight from that's like contract law 101, right? But yeah, I don't understand Korean contract law, so in the United States that would be pretty shitty, pretty damaging to IronMace. This section alone, yeah, is fairly damaging. Again, One thing about this section is that IronMace that does go in IronMace's favor is that it can be argued that the entire section of this document is invalid due to federal laws in Korea, such as the Trade Secrets Act. I'm unsure of how Korean law handles language in contracts that is in direct opposition or already codified as law in Korea. That has yet to be seen. I'm not, I would like to speak to a Korean law expert if I can. And then going forward into Section 6, the company may terminate this contract or refuse to renew the contract within 30 days prior notice, or with 30 days prior notice if the worker falls under any of the following cases. One, in case of violating obligations of Section 5, so if referring to this, if they failed to uphold this, they can be fired, basically, and it invalidates this contract, right, with given 30 days prior notice. Or they can refuse to renew the contract, which would be in December, because that's when Mr. Choi's contract was over. And all of this contract is pertaining to Mr. Choi only, right? Number 4 is also big. In case a worker engages in misconduct in relation to work or receives dishonest money, etc. So basically, if Mr. Choi was recruiting people at work, that can be labeled as misconduct in relation to work, which would allow Nexon to terminate his contract, right? And then in case of violating other internal regulations of the company, they could make this contract invalid. One thing I did want to point out in Section 5, so see how this says not only during employment, but also after departure from the company? It doesn't have a stipulation. This one and this one doesn't have a stipulation or any specific language that means that states that should this contract be terminated, that this stays in place, right? There's no permanency. There's no language for permanency in these, other than not only during employment, but also after departure from company. So that can be argued for this section, but there's nothing here other than 1 year, right? So, but it doesn't have any stipulations to directly, if this contract is invalidated or terminated. There's no, even if this contract is terminated, this is still enforced, right? There's no part of that. No language of that. So that's also pretty big. Same thing with this. But yeah, in case of violating other internal regulations of the company, is super vague. But yeah, this section is pretty straightforward. Nexon can terminate this employment contract if any of these 7 paragraphs are violated, essentially giving Mr. Choi his 30 days notice that he's been fired. While the language in the contract is vague, it does seem to be pretty damning towards IronMace, especially the section about misconduct in Section 5. However, there is one thing that may be extremely damaging to Nexon, and that's this green highlighted sentence. So this sentence is extremely important. The company may terminate this contract or refuse to renew the contract within 30 days, with 30 days prior notice, if the worker falls under any of the following, right? And this is according to a lifelong friend of mine who now practices corporate law in California. His name's Matt. Thanks, Matt. This language being included in the contract could be troublesome for both IronMace and Nexon. If Nexon terminated the contract on the day Mr. Choi was fired and effectively gave him his 30-day notice and terminated the contract, that means that Mr. Choi might have a solid argument in Korea that this contract is no longer valid at all, because there's no language that specifies otherwise. Therefore, he would be free to work on whatever he wanted to and use whatever information he wanted for future projects, as long as it didn't violate Korean law, right? Such as, the Trade Secrets Act that they have over there. So as long as he was operating within the framework of the law provided in Korea, this contract may not even be valid anymore. There's actually several ways that this contract may be invalidated that is actually codified in the contract itself. In short, one sentence may invalidate the entire contract, especially because he was given his 30 days notice and told to leave, instead of keeping him on until the end of his contract, which would be in December, and then just refusing to renew, right? So if he was still technically under contract and just taken off of the project, this contract would be completely enforceable. But since he was fired and the contract was terminated after 30 days, the whole thing might be thrown out. Because there's no language in it that says anything stays even after termination of contract, right? Only a few things are given any specific timeline at all. So the final section of this contract is Section 7, which is the miscellaneous section. And it's kind of what IronMace is citing in the United States to try to have the case dismissed, specifically Section 4. So this is the entire section. I'm only going to read Section 4. And it states, in principle, if there is a difference of opinion between parties relating to this agreement, it shall be dealt with through mutual agreement. But if the parties fail to reach an amicable agreement in resolving this dispute, the competent court of jurisdiction shall be the sole central district court. And what that basically means is if they arbitrate or come to some kind of agreement, they have to first try to resolve it themselves in-house. And this is contractually agreed upon between both parties. It says right here, difference of opinion between parties relating to this agreement, which this entire lawsuit is about. It states that they first have to try to handle it themselves in Nexon internally, and then if they can't, then they have to do it in the Seoul Central District Court. So what this section covers is any items that don't fall into any of the others, as well as what to do if this contract is terminated or there is any other form of dispute. The important bit, paragraph 4, stipulates that any differences that cannot be met through arbitration, mutual agreement, the competent court of jurisdiction shall be in Seoul Central District Court. What this means is that should any legal action take place because of the violation of this contract or any other dispute between Nexon and Mr. Choi, it has to take place in Central District Court in Seoul, right? So if this contract is upheld as is, which it seems Nexon is trying to do, this paragraph might be exactly what gets the United States case dismissed, right? This is what they're pointing to. And this is a 100% legitimate translation done by a certified United States court translator. Yeah, this is all legit. However, what we saw in Section 6, it can be argued that this contract is no longer valid, which would throw out that section, right? So that would mean that Nexon, if the contract is no longer valid, Nexon can sue IronMace in the United States. If the contract is valid, then they can't sue IronMace in the United States. So it kind of puts it up to whether or not this contract is going to be invalidated into either a contract dispute or Nexon's hands. If the contract is invalidated, it also frees up Mr. Choi and therefore IronMace to make Dark and darker, because he no longer has to follow the IP agreement. I mean, unless he's in violation of the United States or Korean law, but contractually he would be able to do it. However, this is kind of where we run into some more weird issues, and they are found in another contract. There's a separate contract after the annual salary contract. So that's like the employment contract, and then there's a separate contract that they sign, everybody signs, that is called the Confirmation of Rights Regarding Work-Related Intellectual Property. This one's a little bit longer because the entire thing is basically what this whole case is revolving around. This contract is independent of the contract mentioned above, meaning that even if the above contract is invalidated, this one might still be able to be upheld. What this covers is pretty simple: the IP and trade secrets. For interest of time, I'm only going to put in what I think is relevant to either the United States or Korean case, starting with the opening statement. The opening statement is Nexon Korea Corporation, hereinafter referred to as Party A, and Ju-Win Choi, sorry Mr. Choi, sorry SDF, I probably butchered your name, hereinafter referred to as Party B, enter into the following agreement in connection with the affirmation of the rights of business-related intellectual property. So what they're saying is this entire contract is related to business-related intellectual property. Party A is Nexon, Party B is Mr. Choi. So Section 1, and I'm going to read this section off in full because it's kind of short. In relation to the creation of intellectual property, such as works of authorship, developments, demonstration, inventions, and the like that occurred during the course of Party B's employment with Party A, the purpose of this agreement is to clarify the relationship between the rights of Party A and Party B in this regard. So the purpose of this agreement is to clarify the language of what intellectual property is and what's supposed to happen with it. The definition, Section 2 is the definition of terms, which is pretty important. So job invention means an invention or an idea made by an employee of Party A, so an employee of Nexon, while working as an employee of the Party A in a field related to his or her work in connection with his or her work inventions. Paragraph 2 is work product. Work product means the result of any song lyrics, writing, song composing, song arrangement, performing, writing, editing, designing, or any other creative activity that occurs while Party B is an employee of Party A, and in the course of Party B's conducting work as an employee. So basically anything that they create, any creative work that an employee does while in the employment of Nexon, while conducting work as an employee, would be considered a work product. So that means that it belongs to Nexon. But yeah, Section 2 is pretty vague and covers almost anything done, or Paragraph 2 is pretty vague and covers almost anything done creatively while working at Nexon. Essentially, any idea or creative asset created while on the company time are deemed as Nexon property. This is pretty standard in the United States. However, language like this has been fought over with various outcomes. In the U.S., owning the rights to someone's ideas isn't something enforceable in a contract like this, unless those ideas are directly related to that specific type of work that they're doing, and those work-related tasks or duties. And a good example of this would be if somebody has an idea for a new bicycle design and wants to start a new bicycle business while they're on the clock at a pizza place, and they sketch it out, on a company napkin while on the clock, the pizza place doesn't own the rights to said design. They don't own the bicycle design. The IP would still be the person's. Now, the reason why is because these two things are completely unrelated and have nothing to do with each other, and therefore there's no competition in the marketplace, right? So what the workplace would have legal responsibility to do, and what they could do if they wanted to, was sue the employee for any lost time and materials used to work on their own business. But that's really about it, at least to the best of my knowledge. However, that's in the United States. I don't know about Korea. And realistically, this would be an extremely tough argument for IronMace to make, as Dark and Darker and P3 are both video games, and Nexon is a video game company. So IronMace would essentially have to prove that they are so different as to not even be remotely related. And that's also true, and it's only true in the United States and might not be true in Korea. I have no idea how contract law works in Korea. I'm not a Korean law expert. Section 3, automatic succession of inventions, etc., and confirmation of rights to works. This whole section is super important. In the event of a job invention, so if you look back up, a job invention is any invention made by an employee of Nexon while working as an employee of Nexon in a field related to his or her work and in connection with his or her work inventions. So basically, it's any idea that has to do with their job or is relatable to their job in some way while at work. So in the event of a job invention, etc., performed by Party B, so Mr. Choi, after joining Nexon, the right to be registered as an intellectual property right in Korea or abroad for such job invention shall be deemed to be automatically transferred to Party A at the same time as the invention. So immediately as of thinking of this idea, that idea now is Nexon's. However, if Party B has jointly invented an invention with a third party, the right to be registered as an intellectual property right in Korea or abroad for the job invention that Party B has shall be deemed to be automatically succeeded to Party A, which is Nexon, at the same time as the invention, etc., is made. So that means, basically, even if Mr. Choi was working with somebody completely unrelated to Nexon, say somebody in the United States, on a video game that wasn't related to Nexon, and he did any of that while on the clock at Nexon, Mr. Choi would have to give up his half of the game to Nexon, which is pretty shady. So the parties affirm that intellectual property rights, including the rights to create secondary works, the rights to create editorial works, and the right of work created by Party B in the course of performing his or her duties after joining the company, shall natively occur and belong to Party A in accordance with Article 9 of the current Copyright Act. So as you can see by all the red text, this section is pretty terrible for IronMace. Stuff in red is bad for IronMace, stuff in green is good. I know, simple but effective. It basically says any invention or idea an employee has while working for Nexon is property of Nexon forever, including that invention if that invention is created with the help of completely unrelated third party. Essentially, Nexon takes whatever percentage of the rights the employee would be entitled to from 1 to 100%. So example, like I said, if developer A, so Mr. Choi in this instance, works for Nexon, he creates a game with a group of 9 other developers who don't work for Nexon, he owns 10% of those rights. However, if he worked on it while on the clock at Nexon, or with any assistance from Nexon, including assets, materials, or resources, then his 10% now belongs to Nexon. It is completely predatory, and in the United States, this might not even be enforceable. However, it might be enforceable in Korea, as seen in Article 9 of the Korean Copyright Act, as they mention here. So that part is super damaging to IronMace's case. Now, however, Section 4 provides it changes Section 3 a little bit. Actually, it changes it pretty significantly in one particular instance. And that instance is in paragraph 1. So Section 4 is the rights and obligations. If Party A inherits the rights in the preceding Section 1 from Party A, so from Nexon, it may provide a predetermined compensation to Party B, which is Mr. Choi. So if Nexon inherits the rights of any of that stuff above from, basically Mr. Choi's employment, it may provide a predetermined compensation package to Party B, so Mr. Choi, as stipulated by the bylaws of the company. After this agreement is concluded, if an invention, etc., is made in the course of duty, then a reason such as the change of employment, etc., occurs to Party B, Party B must not use or recreate outside the company, i.e. Nexon, the same or similar content as the invention, etc., inherited by Party A. So notice that the word similar. Can't even be similar content. And that's ever. So Party B shall notify Party A in writing of all inventions made by Party B during the continuation of the employment relationship, and Party A, Nexon, shall be obligated to confirm it without delay. So that means any idea that Mr. Choi had while on the clock at Nexon, he had to, in writing, give to Nexon. And then Nexon has to offer him some kind of predetermined compensation package as outlined by the company bylaws. So yeah, Section 4 is a pretty mixed bag. It essentially says that if Nexon does take IP from employees, said IPs can ask for compensation in accordance with company bylaws. However, I don't know what those bylaws are, and I don't think they're publicly available. I've looked for them and can't find them, and they're not in any of the documentation I've seen. So what we can get from this is that if Nexon paid Mr. Choi for the idea of P3, which he then developed into Dark and Darker, or changed into Dark and Darker, or however that went, then they effectively own that idea forever. It also modifies the rest of the contract to be more of a right of first refusal for Nexon. If they do not pay for the idea, then they can't really claim the ownership of said idea after the execution of the agreement. So it basically says like, hey, yeah, we want this idea, or we don't. And if they don't, then it's basically on hold until the person quits. And if they don't pay for it, then they have no legal right to it, according to their own statements, right? So that could actually, if they didn't pay Mr. Choi for the idea, then this whole contract might be voided anyway, because he's already gone, and they're still trying to claim P3 as their own project, yet they haven't paid him for it, as supposed to be outlined by their bylaws. So Section 5 is actually nothing but good news, as you can see by all the green, for IronMace. And what it says is any matters not set forth in this agreement and any disagreements between parties as to the interpretation of this agreement shall be resolved in accordance with general customary commercial practice. And that has to do with Korean law. In the event of a dispute relating to this agreement that cannot be resolved through consultation between parties, the Seoul Central District Court shall have exclusive jurisdiction of competence for the first instance. So the first trial out of any trials shall be exclusively be held in the Seoul Central District Court. And then it also says that the parties shall comply with this agreement in good faith and in accordance with the principles of good faith, which basically means like both parties have to be willing and able to uphold this agreement in full at time of signing and thereafter. Otherwise, the contract is void. It also states that in this agreement shall be kept by the Human Resources Department team of Nexon. So yeah, nothing but good news for IronMace, at least how it relates to the U.S. case, and specifically Terrence's contract. But in the case of the United States dismissal notice, this contract has the same clause as the salary contract above. However, it does also state that Seoul Central South District Court shall have exclusive jurisdiction for the first instance, meaning that it can only be tried in that court as long as they take the case, right? So as long as that court doesn't deny the case, it has to be seen there first. And they started the U.S. case first. Nexon did. And then, however, there was also paragraph 3, and it could be used to nullify this entire agreement, especially in the case of Terrence. But for Mr. Choi, it is a little bit more difficult to uphold. To have this agreement invalidated, Mr. Choi would basically have to prove that Nexon was not agreeing in the principles of good faith, meaning that they never intended to uphold the contract or violated it intentionally, which could be extremely difficult. However, in Terrence's case, paragraph 3 could very easily invalidate his entire contract. Because of what we've heard and seen, neither Terrence nor Nexon have a copy of his original employment contract, including this section. So, and then even if Terrence does, but Nexon HR doesn't, his entire contract is invalidated, as stated in section 5, paragraph 3. So, why are these important? It should be obvious by now that this contract, if upheld, could have significant impact on both the Korean and U.S. case. In Korea, it could turn into, what should be an easy win. It could turn what should be an easy win for IronMace into a tough and long-fought contract dispute. There are issues with both arguments as far as this contract is concerned. If Nexon was not operating in good faith, did not pay Mr. Choi for his idea, did not keep a copy of their contract, or does not uphold the United States dismissal, then there are grounds to have this employment contract terminated and invalidated, at least in part, right? In the U.S., it could cause a case against IronMace to be dismissed entirely. In fact, this contract pretty clearly states that it should be. The only thing really preventing this case is that IronMace has already technically accepted the United States as a suitable place to hold the trial by responding to the DMCA and appearing to the court summons. They basically said, yeah, Washington's fine, when they responded to the DMCA and the summons. And then, according to Nexon, IronMace should have disputed the case and asked for a dismissal before doing any of that. Both arguments are relatively true from Nexon and IronMace, so that would be basically up to the judge, which we'll find out in the early case conference. However, if Nexon does not agree with the United States dismissal, which they have not, they actually objected to IronMace's dismissal notice, then this entire contract can be called into question in Korea because they're no longer operating in good faith. They're violating their own contract willingly. So if basically Nexon now finds themselves in a catch-22, because if they uphold the case in the United States, then they're in violation of their contract intentionally, which no longer makes them acting in good faith. So what does this mean? What's the TLDR? And what's my opinion? Well, in my opinion, the contract is pretty clear. Nexon either has to really drop the United States case, or IronMace can argue that the entire contract is invalid. I mean, it's clearly stated in both contracts, in the annual salary contract and the IP contract. However, should this contract stand as is, then IronMace could be in trouble in Korea. if the contract stands, then the United States case will most likely get dismissed or should be dismissed because it says so in the contract. But the contract does have extremely vague language and might be considered unenforceable in the United States. However, the Korean courts are different and have different contract/employment contract and employment laws. It's impossible for me to know how that would play out in Korea without consulting an expert in Korean law. But what I do know is that both sides are in kind of a bind because of this contract, and the waters are extremely muddy. There's no real clear-cut resolution because both parties have violated the language in the contract at some point. And what it really comes down to is if P3 or Darker Darker was invented while on the clock at Nexon. If Nexon paid Mr. Choi or Terrence for the idea itself, or if Nexon upholds the US case. We don't really have the answers yet, but these answers should come in court, so we should be seeing this through deposition or through discovery, through evidence. So it should come through discovery. And then as for early access, everything kind of still hinges on the early case conference in the United States and then the preliminary injunction hearing in Korea. So we should have more information between July 20th through July 27th as those hearings play out. But yeah, that's pretty much it. Sorry it's not as happy and filled with hopium as most of my videos are, but you know, I got to remain as unbiased and honest as possible and act in a way that's truthful and honest as I can be, and with as much evidence and knowledge as I can get, right? But yeah, there it is. I hope you guys liked the video. Don't forget to like, follow, subscribe, and click that notification bell so you guys could get immediately notified of all my videos and when I go live. Please consider joining the guild on Patreon or by following the YouTube membership in the link below. As always, I love you guys. Each and every one of you guys is a champion. Thank you guys so much for watching. Peace.